Hello, and thanks for joining us today on USSC Live, the United States Sentencing Commission series of interactive webcasts produced in conjunction with the Administrative Office of the U.S. Courts and the Federal Judicial Center. On this edition of USSC Live, we have the details on the new amendments going into effect on November 1st, 2014. I'm Krista Rubin.
And I'm Rachel Pierce. We'll have an in-depth review of the new amendments to the sentencing guidelines. First, we'll focus on the Drugs -2 amendment. This amendment will reduce by 2 offense levels the base offense levels applicable to most quantities on the drug quantity table at 2D 1.1. The Commission voted unanimously on July 18, 2014 to make this drug amendment retroactive. We'll take an in-depth look at the application of this retroactive amendment.
And later, we will turn our attention to the additional amendments to the sentencing guidelines to include the Violence Against Women's Act, undischarged terms of imprisonment, felon in possession offenses, alien smuggling, and the resolution of circuit conflicts. So we have a lot to cover today.
But first, we would like for your help. Please submit your questions using the box below or write us at training@ussc.gov. We will post the email address throughout the program and we'll do our best to answer those questions as we receive them.
As we've been updating you during our previous webcasts this year, the Commission has been holding public hearings, soliciting public comment, and voting on proposed amendments to the guidelines. Today, Rachel and I will discuss the application of the new amendments, which are the culmination of all this hard work, and they go into effect on November the 1st. Let's get started with the discussion of the Retroactive Drugs -2 amendment. But before I turn to Rachel, let me point out that there are a number of resources on the Commission's website to assist the court with the application of the Retroactive Drugs -2 amendment. USSC.gov includes most frequently asked questions, a retroactivity primer, the amendment language, and the background information related to this amendment. So please visit USSC.gov.
Thanks, Krista. The first amendment we'll discuss today is the amendment we've been referring to as Drugs -2. This amendment reduces by 2 offense levels the base offense levels applicable to most quantities on the drug quantity table at the guideline 2D 1.1, and on the quantity tables for chemicals at the listed chemicals guideline 2D 1.11. Let's take a look at an example to further illustrate this change, a comparison of the drug quantities for powder cocaine necessary to trigger a particular base offense level under the 2013 Guidelines Manual versus the manual that goes into effect November 1st, 2014. So for example, look at base offense level 32. Under the 2013 Guidelines Manual, base offense level 32 would apply in a case involving 5 kilos of powder cocaine. However, effective November 1st, 2014, a base offense level of 32 would apply in a case involving 15 kilos of powder cocaine. Exactly. You can see on this graphic how the quantities triggering base offense levels on the drug quantity table have been reduced by 2 levels. Let's look at another example. A base offense level of 20 under the 2013 Guidelines Manual requires 200 grams of powder cocaine. However, effective November 1st, 2014, a base offense level of 20 applies in a case involving 300 grams of powder cocaine. Similar corresponding changes have been made to the chemical quantity table at 2D 1.1, the guideline addressing the unlawful distribution or possession of a listed chemical.
Now, these changes to the tables at 2D 1.1 and 2D 1.11 are prospective, meaning that any defendant sentenced in federal court for a drug trafficking or a listed chemical offense on or after November 1st, 2014, will have their guidelines calculated using these reduced penalties. However, as Rachel mentioned in the opening of our webcast, the Commission voted unanimously to make this drug amendment retroactive, meaning that this amendment can be applied to drug offenders who have already been sentenced. Let's take a look at a clip from our last webcast when Kathleen Grilly, General Counsel for the Commission, discussed this retroactive amendment.
Because this amendment reduces penalties in the area of drug offenses, the Commission had a statutory obligation to consider whether it should be applied retroactively. that is, to drug offenders who have already been sentenced. To help inform the Commission's consideration of this issue, the Commission directed staff to prepare a retroactivity impact analysis of the proposed amendment, which, among other things, estimated the number of offenders who might benefit from retroactive application of the drug amendment. The Commission also held a public hearing and solicited public comment on the issue.
So, on July 18, 2014, the Commission voted unanimously to make the drug amendment retroactive. As a result, the Commission added to the Guideline 1B1.10 Amendment 782, which is the amendment number corresponding to the Drugs Minus 2 amendment. Guideline 1B1.10 is the guideline that addresses reduction in terms of imprisonment as a result of an amended guideline range.
However, let me point out something very important here. Although 1B1.10 will be amended effective November 1st of 2014, the Commission added a special instruction regarding the implementation of this amendment. And that is, any order reducing terms of imprisonment for the Drugs Minus 2 Retroactive Amendment cannot be effective until November 1st, 2015.
Now, Krista, what that means is that once the amendment takes effect on November 1st, the sentencing court can consider a possible sentence reduction for inmates meeting certain criteria set by the statute at 18 U.S.C. 3582C2 and the Commission's policy statement at 1B1.10. Inmates can apply for a sentence reduction beginning November 1st, and the courts should consider these petitions beginning on or around November 1st when the amendment goes into effect. However, the earliest any offender can be released pursuant to retroactive application of Amendment 782 is on November 1st of 2015.
Okay, so we've described the Drugs Minus 2 amendment itself, and we've mentioned that the amendment is retroactive, although offenders who are eligible for reduction under Amendment 782 will be released no earlier than November 1st of 2015. We're now going to discuss the statutes, guidelines, and law that provide the authority for the courts to reduce a term of imprisonment. So, Rachel, what does retroactivity mean in the context of the sentencing guidelines?
Retroactivity of a guideline amendment allows the sentencing court to consider a possible reduction of imprisonment for inmates meeting certain criteria set by statute and 1B1.10. Please note that retroactivity of a guideline amendment does not affect the retroactivity of a statutory penalty. Let's take a look at a couple of statutes pertinent to the retroactivity discussion.
Now, the Commission's organic statute at Title 28, Section 994U of the U.S. Code provides the authority for the Commission to specify in what circumstances and by what amount the sentences of prisoners serving terms of imprisonment may be reduced. And so the Commission highlights those situations and provides those recommendations in the guidelines applicable for a particular offense. So at 1B1.10, the Commission has listed those particular circumstances. So what's important to note about the language of this statute is that the Commission, again, is permitted to specify specific circumstances regarding when reductions in terms of imprisonment are warranted. So for Amendment 782, for example, the Commission specified that no inmate is to be released until November 1st of 2015.
The statute at 18 U.S.C. 3582C2 provides that when a sentencing range has been lowered by the Commission, upon motion of the defendant, the Director of the Bureau of Prisons, or the court on its own motion may reduce the term of imprisonment after considering the factors in 18 U.S.C. 3553A, if such a reduction is consistent with the applicable policy statements that have been issued by the Sentencing Commission. So, two things to mention at this point. First, note that the statute says that the court may reduce the term of imprisonment. The judge has full discretion in this matter. Not everyone who petitions the court will automatically receive a reduction in their sentence. Second, the reduction must be consistent with the applicable policy statements of the Commission, which is where Guideline 1B1.10 comes into play.
Exactly. Now, we already mentioned 1B1.10 and explained that the Drugs Minus 2 Amendment, number 782, has been added to the Guideline, which indicates that inmates may seek a reduction in their term of imprisonment based upon the Drugs Minus 2 Amendment. So Guideline 1B1.10 implements the Commission's authority under 28 U.S. Code 994 and provides guidance and limitations regarding sentencing reductions under 18 U.S.C. 3582C2. So one such limitation that's provided at 1B1.10A3 states that proceedings in the reduction of a sentence under the statute and under Guideline 1B1.10 do not constitute a full resentencing of the defendant, meaning that the proceeding is limited in scope and in purpose. The proceeding is not the time for the parties to argue guideline application issues or variances.
The Supreme Court in Dillon versus the United States held that given the limited scope and purpose of hearings contemplated under 18 U.S.C. 3582C2, the interests identified in the Booker decision are not implicated. In fact, courts are bound by the guidance and limitations contained in the Commission's policy statement at 1B1.10. Courts are not authorized to conduct a full resentencing during these hearings. What is only permitted is a sentence reduction within the narrow bounds established by the Commission. In fact, Rule 43B4 states that the defendant not even need to be present for such a proceeding where a sentence is going to be reduced pursuant to 18 U.S.C. 3582C2.
Well, now that we have a general understanding of Guideline Amendment retroactivity, when we come back, Rachel and I will walk you through the process to determine if a defendant is eligible for a sentence reduction, and if so, to what extent a reduction is warranted.
Sounds good, Krista. And this is also a perfect time for you to get your questions in if you have them. Please send your questions to training@ussc.gov or use the box below. It's as simple as that. We'll see you right after the break.
The United States Sentencing Commission website is your one-stop shop that offers a multitude of services for employees. The interactive source book provides a wide range of federal sentencing data. Follow the Commission on Twitter under the Spotlight tab or take online CLE accredited classes. USSC.gov, a reliable source.
Welcome back. If you are just now joining us, earlier in the webcast, we discussed the Drugs Minus 2 Amendment, and we covered the Guideline Amendment retroactivity. If you missed it, don't worry. After the show, we're going to post this entire webcast on the USSC.gov webpage for your convenience. Now, when we left off, we were discussing the process required under 1B1.10.
That's right. We want to walk you through the process to determine if a defendant is eligible for a sentence reduction, and if so, to what extent. Now, this process required under 1B1.10 involves 3 steps. First, the court will need to determine if the defendant is eligible for a reduction. Not every inmate who applies for a reduction in sentence under the Drugs Minus 2 Amendment will be eligible for a reduction in sentence. Second, if a defendant is eligible for a reduction, the court will then need to determine the extent of the reduction allowable. And third, after the court determines that a defendant is eligible and the extent of the reduction allowable, then the court must then consider public safety and other factors to determine to what extent a reduction should be warranted. So as we mentioned, the judge has full discretion in this matter.
That's right. When beginning this process, it is important for everyone to remember that the version of 1B1.10 in effect on the date of the proceeding at which the judge will issue the order of reduction is the version that is to be used. This is a crucial piece of the process because the Commission amended Guideline 1B1.10 effective November 1st, 2014. We do not want any of our viewers to be misled, thinking that the Drugs Minus 2 Retroactive Amendment will be the same as the retroactive crack amendments in 2008 and 2010. 1B1.10 is a different policy statement, and we'll be sure to highlight the differences as we proceed through our discussion of application.
Absolutely. Thanks, Rachel. Okay, so let's go on to the first step of the process, determine if the defendant is eligible for a reduction. For this first step, there are 3 criteria that need to be met. First, the defendant must be serving the term of imprisonment. This means that the defendant must be serving the term of imprisonment for which he is seeking a reduction in sentence. Defendants who are serving a term of imprisonment due to a revocation of their supervised release or probation are not eligible. Additionally, 1B1.10 does not authorize a reduction for any other component of a sentence, such as a term of supervised release, a fine, or restitution.
Okay, so the first criterion is to establish if the defendant is in fact serving a term of imprisonment. The second criterion is that the amendment must be listed at 1B1.10. As previously mentioned, Amendment 782, the Drugs Minus 2 Amendment, will be included in 1B1.10 effective November 1st, 2014. However, let me caution you that the Drugs Minus 2 Amendment does not just affect defendants convicted of a drug trafficking crime. This amendment may also affect any defendant sentenced under the drug guideline. For example, a defendant who is convicted of a money laundering offense, whose base offense level was determined using 2D1.1, or maybe a defendant who is convicted of a felon in possession offense who was cross-referenced over to the drug guideline. Now, the third criterion to determine whether a defendant is eligible for reduction is a bit more involved. The court must now determine if the guideline range applicable to the defendant subsequently has been lowered as a result of the listed amendment. That is, does Amendment 782, the Drugs Minus 2 Amendment, reduce the guideline range applicable to a particular defendant?
So in order to determine whether the guideline range has been lowered, the court will substitute only the amendment listed at 1B1.10 for the corresponding provision applied at the previous sentencing. What this means is that the court will substitute the offense level from the new drug quantity table effective November 1st based upon the quantity that was established at the defendant's previous sentencing. All other previous guideline determinations remain unaffected. As we mentioned, this is not a full resentencing of the defendant. The court is limited to only looking to the new drug quantity table to determine if a defendant's previous guideline range has been lowered. Please also note that an amendment listed at 1B1.10 may not always lower the defendant's applicable guideline range. This is primarily due to the operation of other guidelines or statutory provisions. So, Rachel, let's give some examples.
Sure, Krista. There are a few examples where the Drugs Minus 2 Amendment may not result in a lower guideline range for some defendants. First, in cases involving a very large quantity of drugs, where the defendant's offense level is 38 based on that large drug quantity. In some instances, the quantity of drugs will keep the defendant at an offense level of 38. For example, the amended drug quantity table provides an offense level of 38 for powder cocaine cases involving 450 kilos or more. If the defendant was previously held accountable for a quantity of powder cocaine exceeding 450 kilos, the defendant's guideline range will not be reduced and he would not be eligible for a reduction. The second example would be at the opposite end of the spectrum. Drug cases involving very small quantities of a controlled substance where the defendant's drug quantity is determined using the lowest base offense level on the drug quantity table. For example, the lowest offense level at the drug quantity table for powder cocaine cases is 12. Effective November 1st, an offense level of 12 is triggered by less than 50 grams of powder cocaine. If the defendant's drug quantity is less than 50 grams, the guideline range for that defendant is not reduced. Therefore, that defendant would be ineligible for a reduction.
And another example of a case in which the Drugs Minus 2 Amendment may not result in a lower guideline range is where the defendant's offense level was determined by using the career offender guideline at 4B1.1. Now, this is because the drug guideline calculations are generally overridden by the career offender guideline as provided at 4B1.1. And finally, some defendants who did not receive a government motion for providing substantial assistance may have a mandatory minimum penalty that is in excess of the applicable guideline range. In a case in which the mandatory minimum statutory penalty for the drug offense is greater than the otherwise applicable guideline range, the guideline range for that defendant has not been lowered. So for example, if the defendant is facing a mandatory minimum penalty of 120 months, and the court determines that the guideline range using the new drugs -2 amendment is 97 to 121 months, that defendant would not be eligible for a reduction because his guideline range remains at the statutory minimum penalty of 10 years.
So, to summarize, the first determination for the court is to discover if a defendant is eligible for a reduction. All three of the following criteria must be met. The defendant, number one, must be serving a term of imprisonment. Number two, the amendment must be listed at 1B1.10. And finally, the guideline range applicable to the defendant must have been lowered as a result of the amendment. If any one of the three criteria I just mentioned is not met, the defendant is not eligible for a reduction in sentence. If the defendant meets all three criteria, we can move on to step 2 of the retroactivity process, which is determining the extent of the reduction allowable. The policy statement at 1B1.10 provides limitations on the extent of reduction. One prohibition on the extent of reduction is that the reduced term of imprisonment cannot be less than the term of imprisonment the defendant has already served. For example, the defendant's original sentence was 63 months. The defendant's guideline range, let's say, has been lowered to 51 to 63 months. The defendant is eligible for release January 1st, 2016, after serving 63 months. When the order takes effect on November 1st, 2015, by that time, the defendant will have already served 61 months. The court should state that the sentence is reduced to a term of 61 months in a case like this. The court may not reduce the term of imprisonment to 51 months, which is a reduction of 12 months, as that would be less than the amount of time the defendant has already served.
And additionally, Rachel, there is a general limitation on the extent of the possible reduction. That is, the term of imprisonment cannot be reduced to less than the minimum of the guideline range. However, as our viewers will hear throughout the remainder of this segment on retroactivity, there is an exception in cases involving substantial assistance motions. But let's take a look at an example of this general limitation. So in this example, the defendant's previous guideline range was 41 to 51 months. The court imposed a sentence of 46 months, the middle of the guideline range. After calculating the new base offense level at the drug quantity table, the amended guideline range is 33 to 41 months. The court cannot reduce the defendant's sentence to less than 33 months, the minimum of the amended guideline range.
Now, Krista, I think it's important to point out here that if in the previous sentencing the court departed or varied from the guideline range, there is no comparable reduction to account for the sentence outside of that range. Regardless of whether the court went below the otherwise applicable range, the court cannot reduce the defendant's sentence to less than the minimum of the amended guideline range. There is, however, as we mentioned, an exception in cases involving substantial assistance. So here's an example. The original guideline range in this case was 41 to 51 months. The court departed below that guideline range and imposed a sentence of 35 months. After considering Amendment 782 under 1B1.10, the amended guideline range is now 33 to 41 months. The court may reduce the sentence to 33 months, the minimum of the amended guideline range, but the court is not permitted to reduce the sentence 6 months below the minimum of the new amended range, as the court did in the initial sentencing.
So, Rachel, if, for example, the court had, at the initial sentencing, varied from the guideline range to a sentence of 31 months, the defendant would not be eligible for a reduction in sentence under Amendment 782 because the minimum of the amended guideline range is greater than the sentence that was initially imposed by the court.
That's correct. Now, as we have been reminding our viewers throughout this webcast, there is an exception in cases involving substantial assistance. We've just reviewed situations in which the court departed or varied below the guideline range for cases not involving a substantial assistance motion. We've discussed that the court may not reduce the sentence below the minimum of the amended range, and the court may not grant a comparable reduction based upon the initial departure or variance granted. However, in cases involving substantial assistance motions, the rules are different.
That's correct, Rachel. There is an exception to the rule in cases involving substantial assistance. If the previous sentence was pursuant to a government motion for substantial assistance under 5K 1.1, 3553E, or Rule 35B, the court may impose a reduction comparably less than the minimum of the amended guideline range if the court believes that's appropriate. So, for example, the guideline range at the initial sentencing was 70 to 87 months. Based on a substantial assistance motion, the court imposed a sentence of 56 months, which is a departure of 20% below the minimum of the guideline range, which was 70 months. So upon application of the Retroactive Drugs Minus 2 Amendment, the amended guideline range is 57 to 71 months. The court is permitted to provide a comparable reduction based upon the substantial assistance departure. So what this means is that the court is permitted to grant a reduction of 20% below the minimum of the amended guideline range. So in this example, the defendant is eligible to receive a reduction to 46 months, which is 20% below the minimum of the new amended guideline range of 57 months.
There is another reason why cases involving substantial assistance motions are treated differently when applying the Retroactive Drugs Minus 2 Amendment. Everyone needs to be aware that in addition to listing the Drugs Minus 2 Amendment at 1B1.10, the Commission also amended 1B1.10 itself to address a circuit split on retroactivity regarding the extent of reduction that can be granted in cases in which the previous sentence was below a mandatory minimum based on substantial assistance.
That's right. And here is the new amendment to 1B1.10. 1B1.10 has been amended to clarify that if the defendant is subject to a mandatory minimum and the defendant received a government motion under Title 18, Section 3553E, or under Rule 35B to reflect substantial assistance to authorities, the amended guideline range shall be determined without regard to the mandatory minimum. That is, without regard to the operation of guidelines 5G 1.1 and 5G 1.2.
And as always, Krista, an example is the best way to illustrate the application of this amendment. So let's take a look at one now. In this case, the defendant was subject to a mandatory minimum of 120 months. The original guideline range was 135 to 168 months. Based upon the defendant's substantial assistance under 3553E, the court imposed a sentence of 101 months, a departure of 25% below the minimum of the original guideline minimum, 135 months. After application of the Retroactive Amendment 782, the amended guideline range is 108 to 135 months. Because the defendant was relieved from the mandatory minimum of 120 months based on that 3553E motion, the amended guideline range is not 120 to 135, but remains as 108 to 135 months. The court then is permitted to provide a reduction of 25% from the 180-month minimum of that amended range. That comparable reduction would be 81 months.
So let's take a look at another example. In this case, the defendant was subject to a mandatory minimum of 120 months. The guideline range was 108 to 135. However, because of the mandatory minimum penalty, the guideline range became 120 to 135 months. Now, based upon the defendant's substantial assistance under 3553E, the court imposed a sentence of 90 months, which is a reduction of 25% below the minimum of the guideline range of 120 months. Now, after application of the Retroactive Amendment, number 782, the amended guideline range is 87 to 108 months. Now, because the defendant was relieved from the mandatory minimum penalty of 120 months, based upon the 3553E motion, the amended guideline range is not 120 months, but remains as 87 to 108 months. So the court then is permitted to provide a reduction of 25% below the minimum of the guideline range, the amended range, 87 months, and that comparable reduction would be 65 months.
As our viewers can see, in cases involving defendants subject to substantial assistance motions, there are additional considerations for the court in determining the extent of reduction available for a particular defendant. As the courts are processing these motions and reviewing the defendants who are eligible for reduction, court staff may want to consider defendants with substantial assistance motions separately from those defendants who do not have substantial assistance motions, as there are these additional considerations for the court. It just make the process a bit easier.
Absolutely. Well, we have discussed 2 of the 3 steps of the retroactivity process under 1B1.10. We started off by discussing the 3 criteria to determine if a defendant is eligible for reduction. Serving the term of imprisonment, the amendment has to be listed at 1B1.10, and the guideline range has been lowered for that defendant. Now, we just finished our discussion of determining the extent of the reduction allowable. The court is not permitted to reduce the sentence below the minimum of the amended guideline range, but for those cases involving substantial assistance, there are additional considerations for the court in determining the extent of that reduction. So now we're going to discuss the 3rd step for the court to conduct in retroactive application of the Drugs Minus 2 Amendment. The court must now consider specific factors to determine if a reduction is warranted, and if the court determines that a reduction is warranted, the court will consider these factors to determine the extent of that reduction.
That's right, Krista. The decision to reduce the term of imprisonment is entirely within the judge's discretion, and we've mentioned that already this afternoon. There are factors in 1B1.10 that the judge is to consider when determining whether a reduction in sentence is warranted, and if so, the extent of that reduction. Within the limits established by 1B1.10, as to the extent of the reduction allowable, the court is to consider the factors listed at 18 U.S.C. 3553A. The court is also to consider public safety, the nature and seriousness or the danger to any person or the community that the defendant might present. And finally, the court may also consider the post-sentencing conduct of the defendant. That is, the conduct the defendant has had since the imposition of the previous term of imprisonment. Century reports from the BOP might be helpful in having the court consider this particular factor. And of course, in some cases, the post-sentencing conduct will be beneficial to the defendant, and for other defendants, post-sentencing conduct may not be.
Well, and the important thing to remember regarding this process of retroactivity is that although a defendant may be eligible for a reduction based on the criteria at 1B1.10, and the court determines that there is room based upon the amended guideline range for a reduction, the court must consider these factors to determine if a reduction should be granted, and if so, to what extent. And, as we continue to mention, this is entirely up to the judge.
Now, we're going to take a quick break. Again, it's a good time for you to get your questions to us if you have them.
Absolutely. So please send your questions to training@ussc.gov or simply type in your question using the box below.
When we come back, we're going to hear from you, so stay with us.
Looking for the latest sentencing guidelines? Rely on USSC.gov. This interactive website provides commission news, training opportunities, publications, and the interactive sourcebook. Also, get the latest tweets on our new Twitter page at the USSC.gov. Welcome
back. During the break, we received a lot of questions that we're going to answer before moving on to the other amendments that will be effective November 1st, 2014. One of the first questions we got was whether or not the slides that we're using this afternoon are going to be available on our website, and they are in fact going to be posted on our website. So no worries there.
That's it. That's right. And so we've got a couple of other questions that we are going to deal with. And the first question that we received is from a district that implements binding plea agreements under Rule 11C1C. And so the question is, what is the impact of a binding plea agreement when processing retroactive drug -2 motions? Basically, is the defendant eligible for reduction when there is a binding plea agreement? And in fact, there is a Supreme Court case addressing this issue, Freeman versus the United States, which was decided in 2011. And the Supreme Court said that a sentence resulting from a binding plea agreement is not categorically disqualified from a retroactive reduction under 18 U.S.C. 3582C2. Now, in considering whether a defendant with a binding plea agreement is eligible for a reduction in sentence, an agreed upon sentence established by reference to the applicable guideline range may be among those that are not categorically disqualified from retroactive consideration. So, for example, if the plea agreement established that the sentence would be determined perhaps by providing a 4-level reduction from the minimum of the guideline range, that might be a case in which it would not be categorically disqualified. So the court's going to have to consider each of these situations carefully. And there is case law on the issue. I think the First, Fourth, Sixth, and the Ninth Circuits have decisions addressing the binding plea agreements issue. So don't forget to look at case law if you have these types of situations in your circuit. So let's move on to another question.
Sure, Krista. Another question we received is from John Gobert, probation officer from the Southern District of Illinois. And his question is, for defendants who previously received a reduction in sentence under the most recent retroactive crack amendment, are they eligible to receive yet another reduction in sentence under Amendment 782, which is the drugs minus 2 amendment? And the answer to your question, John, is yes, as long as they meet the required criteria that we've been talking about established under 1B1.10. What is important to remember about defendants who have previously received a reduction, however, is that the drugs minus 2 amendment will be substituted for the corresponding 2D1.1 calculation that was done at the time of the previous reduction. So, for example, if a defendant received a reduction under Amendment 750, which was relating to the Fair Sentencing Act in 2011, the court will substitute the drug calculation that was done in 2011 with the new drugs minus 2 amendment. So here's an example. The original guideline range in 2009 in this case was 168 to 210 months. In 2011, the defendant received a reduction in sentence to 140 months based upon the new amended guideline range of 140 to 175 months. Now, using Amendment 782, the defendant could receive another reduction up to 120 months based upon the new amended range of 120 to 150 months.
And Rachel, another question that we've received has to do with sort of the mechanics of guideline application. And so throughout the webcast, we've been emphasizing that in considering a possible reduction in sentence, all previous application decisions will be unaffected in the determination of the guideline range. However, sometimes the mechanics of guideline application can impact the offense level and the resulting range. So let's talk about some examples of when this will occur.
Sure, because it's a really good question. There are 2 examples that we can give you. First involves the application of the mitigating roll cap at the drug guideline. The amount of reduction contemplated by the mitigating roll cap at 2D1.1 depends upon the offense level. For example, if at the original sentencing the defendant's drug quantity was an offense level of 38, but due to his mitigating role in the offense, the base offense level was reduced 4 levels to a 34. Well, now under the drugs minus 2 amendment, that same defendant's new base offense level is reduced from 38 to 36. So as a result, the 4-level reduction for the mitigating roll cap no longer applies. Because if the offense level is now 36, the reduction that's available based upon the mitigating roll cap is now 3 levels instead of 4 for a new offense level of 33.
And you know, Rachel, another example involves the application of acceptance of responsibility. So in this example, the original offense level was 16 based upon the drug quantity table. The defendant then received a 3-level decrease for acceptance of responsibility at Guideline 3E1.1 for a final offense level of 13. Now, after application of the drugs minus 2 amendment, the defendant's offense level is reduced to level 14. As a result, the defendant is no longer eligible for a 3-level decrease under acceptance of responsibility because of the simple fact that the offense level is less than 16. So as a result, the defendant will only receive a 2-level reduction for acceptance at 3E1.1 for a final offense level of 12.
That's right. Now, the next question we have is more procedural. We have received some questions regarding the appropriate form that's to be submitted to the Commission when the court is processing these orders regarding motions for sentencing reduction. So let me give you some background on this issue. On October 7th, Judge Patty Saris, chair of the United States Sentencing Commission, sent a memorandum to all judges, clerks, and chief probation officers that provided guidance regarding the appropriate form to be used in processing these retroactive motions. That appropriate form is the AO 247 form, which you can now see on your screen. This form was developed specifically for courts to use in these matters. The Commission plans to collect and report data on the court's decisions regarding motions to apply Amendment 782 retroactively. The Commission asks that copies of all orders in these matters are sent to the Commission, regardless of whether the motion for a reduced sentence was granted or denied, and regardless of whether the offender was found to be eligible to seek a reduction under the amendment.
And we've been getting a specific question about one section of this form, and you can see that particular section on your screen. Now, as we mentioned earlier in the webcast, reductions in sentence pursuant to Amendment 782 are not to take effect until November 1st, 2015, although courts are urged to begin processing these motions November 1st, 2014, or soon after that, the date the amendments will be in effect. So it's important to remember that the effective date for any of the motions considered by the courts, basically from November 1st of 2014 until October 31st of 2015, is November 1st, 2015. So on the line entitled Effective Date, please enter November 1st, 2015. The court does not have to calculate the release date for each defendant.
These are all great questions.
Yes, and we appreciate you sending them in. And continue to let us know what's on your mind by writing us at training@ussc.gov or using the box on the website. When we come back, we're going to discuss application of the other amendments to the guidelines effective November 1st, 2014, so you definitely don't want to miss that. We'll see you in a few.
The United States Sentencing Commission website is your one-stop shop that offers a multitude of services for employees. The interactive source book provides a wide range of federal sentencing data. Follow the Commission on Twitter under the Spotlight tab or take online CLE accredited classes. USSC.gov, a reliable source.
Welcome back. So far, we've discussed the Drugs Minus 2 Amendment, the retroactive application of the Drugs Minus 2 Amendment, and the amendment to Guideline 1B1.10, resolving a circuit conflict about mandatory minimums and substantial assistance. So now we'll discuss application of the other amendments to the guidelines effective November 1st, 2014.
And these amendments address various other provisions of the guidelines. Some address congressional legislation, some resolve circuit conflicts, and others address application and policy issues identified by the Commission. So let's get started.
The first amendment we'll address is the addition of a new specific offense characteristic to the drug guideline 2D1.1. This amendment provides increased punishment for certain defendants involved in the marijuana cultivation operations on state or federal land or while trespassing on tribal or private property. A 2-level increase is provided in a case in which the offense involved marijuana cultivation on state or federal land or while trespassing on tribal or private land, and the defendant receives an aggravating role adjustment at Guideline 3B1.1. One important thing to remember about this new specific offense characteristic is that it will reorder the specific offense characteristics currently at the drug guideline. The new characteristic will be at B14, so the remaining specific offense characteristics will be renumbered. This amendment responds to concerns raised by several interest groups, especially in the area of the country where unlawful outdoor marijuana cultivation is occurring with increased frequency.
Now, another amendment going into effect addresses congressional legislation, and that legislation is the Violence Against Women Reauthorization Act of 2013. Now, this series of amendments responds to recent statutory changes made by the Act. And what the Act did was provide new and expanded criminal offenses and increased penalties for certain crimes relating to domestic violence, assault, sexual abuse, stalking, and human trafficking. The Commission held a public hearing on this issue in February and received information that was very helpful to the promulgation of these amendments. Now, specifically, what the amendment will do in the assault guideline at 2A2.2 and the stalking and domestic violence guideline at 2A6.2, they will now have an increase that addresses strangling, suffocating, or attempting to do so to a victim by a spouse or a partner. And this conduct is a significant harm that was not previously covered by the guidelines. Additionally, there's some technical amendments that were made to Appendix A that would help the Commission comply fully with that Act.
Now, this next amendment addresses a circuit conflict and also provides clarification in the application of the guideline 2K2.1, which is the felon in possession guideline. The amendment addresses cases in which a defendant is convicted of a firearms offense and also possessed that firearm in connection with another offense, such as robbery or attempted murder. First, the amendment clarifies the operation of relevant conduct regarding possession of a firearm in connection with another offense. Specific offense characteristic B6 and the cross-reference at 2K2.1 are the provisions that account for this conduct. The amendment adds examples to the application notes to clarify that in considering application of the specific offense characteristic B6, the court should consider whether the firearm offense of conviction and the unlawful possession of a firearm in connection with another felony offense were part of the same course of conduct or common scheme or plan as the offense of conviction as contemplated by relevant conduct. Second, the amendment also responds to concerns regarding the impact of the cross-reference at the felon in possession guideline, particularly in cases in which the defendant was convicted of unlawfully possessing a firearm on one occasion, but was found to have possessed a different firearm on another occasion and in connection with another more serious offense. In this regard, the amendment specifies that the cross-reference will be applicable only when the firearm listed in the offense of conviction was in fact the firearm that was used in connection with another offense. Now, Krista, the next amendment also addresses a circuit conflict, so can you tell us about that?
Absolutely, it sure does. The next package of amendments addresses supervised release issues at Guideline 5D1.2. Now, first, a new application note was added to explain the impact of a mandatory minimum term of supervised release on the supervised release range that's actually called for in Guideline 5D1.2. So, for example, if 5D1.2 requires a range of 2 to 5 years of supervised release, and the statute requires a minimum term of 3 years of supervised release and a maximum term of life, the term of supervised release required by the guidelines under this section will be 3 to 5 years. Now, the amendment also clarifies the impact of statutorily required terms of supervised release on the terms that are called for under 5D1.2. And so there are several examples that are provided in the application note to provide guidance in such situations. Now, often, sex offenses contain mandatory minimum penalties for supervised release with maximum terms of life. And the examples provide additional clarifying language of the various situations that involve these types of statutes.
That's right. Now, the other circuit conflict addressed by this same amendment involves the appropriate term of supervised release in cases involving failure to register as a sex offender offenses. The amendment clarifies that these offenses, failing to register as a sex offender, which can be found at 18 U.S.C. 2250, is not to be considered a sex offense and therefore not subject to the provision at 5D1.2, which would increase the maximum of the supervised release term to life. Now, Krista, the next set of amendments addresses other terms of imprisonment covered under 5G1.3.
That is right, Rachel. Guideline 5G1.3 addresses undischarged terms of imprisonment. That is, a case in which the defendant is being sentenced in federal court when he's also serving an undischarged term of imprisonment, usually in state custody. Now, the guideline provides guidance to the court in imposing the federal sentence on whether to run it concurrently, consecutively, or partially consecutively to that undischarged term. So first, the amendment clarifies the operation of 5G 1.3b. Now, 5G 1.3b allows the court to run the instant federal offense of conviction concurrently to the undischarged term of imprisonment, and allows the court to credit the time already served on that undischarged term if the conduct underlying the undischarged term of imprisonment is relevant conduct to the instant offense. Now, this amendment simplifies the operation of 5G 1.3b by removing the requirement that the inclusion of the conduct underlying the undischarged term has to increase the offense level for the instant federal offense.
Now, the second part of this amendment addresses anticipated but not yet imposed state sentences. You may recall the Supreme Court in the Setzer case held that the federal sentencing court has the authority to order that a federal term of imprisonment run concurrent with or consecutive to an anticipated but not yet imposed state sentence. Now, the Commission added a new section to 5G 1.3 stating that if the defendant is facing one of these anticipated but not yet imposed state sentences, then the federal sentence should be imposed concurrently if the state offense is relevant conduct to the instant federal offense. This amendment reduces disparities between defendants whose state sentences have already been imposed and those defendants whose state sentences have not yet been imposed.
Right. And another part of this amendment addresses concerns regarding the amount of time a defendant serves in state custody after being located by immigration authorities. And so several courts have recognized a downward departure to account for the delay between when the defendant is found by immigration authorities and when the defendant is brought into federal custody. So to address this situation, the Commission has added a departure provision to the Illegal Reentry Guideline 2L1.2 to address such a circumstance. Now, specifically, the court is to consider whether a departure is appropriate to reflect all or part of the time in state custody that the court determines will not be credited to the federal sentence by the Bureau of Prisons. So in considering the departure, the new application note also provides guidance to the court to consider the risk to the public from further crimes of the defendant and provides additional factors for the court to consider as well.
And finally is an amendment in the Alien Smuggling Guideline. This amendment accounts for the risk of death, injury, starvation, dehydration, or exposure that aliens potentially face when transported through dangerous and remote geographical areas. The amendment adds language to an application note to provide an additional example of conduct to which the reckless endangerment enhancement at SOC B6 applies. This specific offense characteristic provides a 2-level increase and a minimum offense level of 18 in alien smuggling cases that recklessly or intentionally create a substantial risk of death or serious bodily injury. Specifically, the new language states that guiding persons through or abandoning persons in a dangerous or remote geographic area without adequate food, water, clothing, or protection from the elements is considered reckless endangerment.
Well, the Commission sure has been busy this year.
That's right. There have been a lot of important changes that we've shared with you on this webcast. Before we wrap things up, let's answer any questions related to these additional proposed amendments for our viewers, if we have any.
We did get a question regarding the retroactivity process.
Okay.
And that question is, how does a federal inmate apply for the reduction? And, you know, I'm not really sure what the process is, but I know that, you know, looking at 3582C2, that you know, it's the defendant can contact the court, I would say, or perhaps the defendant should contact his defender or his attorney and get that process moving. So I think it might vary depending upon in which district you were originally sentenced, but
I think that's fair, and I think it's also fair to say that at some point some sort of motion actually has to be filed with the court, whether it's the defendant filing with his defense attorney or, you know, the court making its own motion, but there has to be some sort of motion filed with the court in order for a defendant to seek a reduction.
That's right. Well, that's all the time we have for today. We spent the first part of our program discussing the Drugs Minus 2 Amendment, retroactive application of that amendment, and the amendment to 1B1.10 addressing mandatory minimums and substantial assistance for retroactive application of the guidelines.
We then discussed the other amendments to the guidelines, including marijuana cultivation, the resolution of various circuit conflicts under the Felon in Possession Guideline and the Supervised Release Guideline. We discussed amendments related to the Violence Against Women Act and the amendments addressing undischarged terms of imprisonment, as well as alien smuggling.
Again, if you missed any of these topics, please revisit this site, USSC.gov, where we will post this webcast in its entirety. Thank you for joining us. Please take a moment and give us some feedback on this webcast. Also, don't forget to let us know if you have any suggestions for future topics. We'll see you next time on USSC Live.